All right, let's jump right into this explainer. Today, we're unpacking the Bharatiya Nagarik Suraksha Samhita, or the BNSS. Now, I know criminal law might sound a bit dry at first, but what we're really talking about here is the absolute razor's edge between the coercive power of the state and your fundamental liberties as a citizen. Think about it. How does a society actually empower its police to catch criminals, while simultaneously guaranteeing that innocent people aren't just arbitrarily thrown into a cell? Well, that is exactly the balancing act we're going to explore today through the framework of the BNSS.
To help us navigate all these complex legal procedures, we've broken things down into 6 quick sections. What is an arrest? Constitutional safeguards, lawful procedures of arrest, medical exams and custody, summons and judicial warrants, and finally, proclaiming an absconding offender. We'll be tracking the escalation of legal action step by step, starting from a basic police investigation and going all the way up to some pretty extreme judicial measures. Let's get to it.
So, Section 1. What exactly is an arrest?
Legally speaking, it's taking a person into custody by restricting their freedom because they're suspected of committing an offense. Picture a guy, let's call him Rohan, who's accused of stealing a motorcycle. The very second the police find him, tell him he's coming to the station, and stop him from leaving, well, he is officially under arrest. It is literally the moment your personal autonomy gets suspended.
Now, here is where it gets really interesting. Under Section 35 of the BNSS, there's a strict threshold based on how severe the crime is. For offenses that carry up to 7 years in prison, police literally can't just arrest you on a whim. They absolutely have to meet specific necessity conditions and actually write down their reasons. But on the flip side, for heinous crimes carrying more than 7 years, life imprisonment, or the death penalty, the police have way more leeway and can make an arrest based simply on reasonable satisfaction.
So you're probably wondering, what exactly are those necessity conditions for the lesser crimes? Well, if an officer decides to arrest someone without a warrant for a crime under that 7-year mark, they've got to legally satisfy at least one of these specific grounds. Are they trying to prevent another offense, stop the suspect from messing with evidence, or maybe keep them from threatening a witness? The officer has to check one of those boxes and document it. It's all about making sure arrests happen out of actual necessity, not just convenience.
Moving right along to Section 2, Constitutional Rights and Safeguards. Because if the police have all this immense power, what's protecting us, right? Well, it all anchors back to Article 21 of the Constitution. It guarantees that no person shall be deprived of their life or personal liberty except according to procedure established by law. Paired with Article 22, this is the ultimate safeguard. It guarantees any arrest has to follow a just, fair, and reasonable procedure. State power is huge, sure, but it is never allowed to completely crush human dignity.
We actually see this play out in some massive legal precedents. Take the Arnish Kumar versus State of Bihar case from 2014. This dealt with Section 498A, regarding dowry harassment allegations. The Supreme Court laid down a huge reality check. Arrests are absolutely not mandatory, even for cognizable offenses under 7 years. Police really have to scrutinize the necessity, and magistrates can't just blindly rubber stamp them. In fact, if police make mechanical arrests without written reasons, they are looking at departmental action and contempt of court.
And this protection just keeps building. Look at the Mihir Shah hit-and-run case from July 2024. Shah basically argued his arrest was completely illegal because they never gave him the written grounds for it. And you know what? The court completely agreed. They affirmed that giving someone the grounds of their arrest in writing, in a language they actually understand, is a mandatory fundamental right under Article 22. Just telling them out loud simply doesn't cut it anymore.
Okay, let's jump to Section 3, Lawful Procedures of Arrest.
So keeping those massive constitutional safeguards in mind, how does an arrest actually physically happen under the BNSS? Sections 43 and 46 lay out the exact rules of engagement. An arrest involves actual touching or confinement. But get this, if you verbally submit to custody, the police don't have to touch you at all. Also, officers are legally mandated to use the absolute minimum force necessary. Routine handcuffing? No way. That's reserved only for extreme situations where someone resists or tries to run, and the officer has to write down exactly why they did it to preserve dignity.
The law also carves out some really vital, empowering protections for women. A woman cannot be arrested after sunset or before sunrise unless there are extreme, exceptional circumstances, and even then, they need prior permission from a magistrate. Plus, arrests and physical medical exams of women must be handled by or at least supervised by female officers and practitioners. There's also a major privacy safeguard. If police have to force entry into a house, any woman inside who doesn't normally appear in public has to be given notice and a reasonable amount of time to withdraw.
You know in movies when someone gets dragged off in the middle of the night and nobody knows where they are? Yeah, Section 48 exists to make absolutely sure that never happens in real life. It strictly obligates the arresting officer to immediately tell a friend, relative, or nominated person that the arrest happened and exactly where the person is being held. This has to go into the official police records, which creates immediate, undeniable accountability.
Moving right along to Section 4, medical exams and custody limits.
Once a person is actually in custody, the state becomes 100% responsible for their health and safety. Sections 51 and 53 mandate medical exams by a registered practitioner right after the arrest. This is brilliant because it serves two massive purposes. Sure, it can gather evidence about the crime, but more importantly, it protects the accused. The doctor has to meticulously record any pre-existing injuries and figure out roughly when they happened. It establishes a physical baseline so the person is completely protected from any custodial abuse.
So how long can the police actually keep you locked up like this? Well, there is a hard legal limit. Under Section 58, a police officer cannot hold someone for more than 24 hours. Now, that excludes the time it takes to travel from the arrest location to the court, but within that 24-hour window, you absolutely must be produced before a magistrate. The police can't just lock you away indefinitely. A judge has to quickly review whether your detention is actually legal.
Now, what if the court needs you, but you aren't out committing a crime that needs a street arrest? That brings us to Section 5, summons and judicial warrants. Think of these as the court's escalation tools for getting you to show up. First, you've got the summons on the left. This is for less serious offenses where they fully expect you're going to cooperate. It's basically a formal written invitation. But on the right, you have the warrant of arrest. This is a highly coercive tool. It's issued if the court thinks you're on the run or if you've just flat out ignored a summons. And once a warrant is out there, it stays active until it's executed or specifically canceled by a judge.
So, how exactly does a summons work? Under Sections 64 and 66, it's a super formal process. An officer hands you a duplicate copy, and you have to sign a receipt right on the back. But here's a wild little legal quirk. If the police really can't find you after trying their best, they can lawfully just hand the summons to an adult male who lives in your household, and he signs for it. Notice that specific phrasing there, adult male family member.
Now, let's say things do escalate to a warrant. It doesn't actually mean you're going straight to jail. Under Section 73, courts can issue a bailable warrant. Basically, the court writes a special endorsement on the warrant telling the officer, hey, if this person can provide a bond with sufficient sureties, which is essentially a financial guarantee that you'll show up to court, then let them go immediately after the arrest. It's a really smart way to make sure people show up without unnecessarily throwing them in a cell.
And finally, we hit Section 6, proclaiming an absconding offender.
We're talking about the nuclear option here. What happens when someone completely evades a judicial warrant? If the court believes you're intentionally hiding, they fire up the proclamation process, under Section 84. They publicly and loudly demand that you appear, giving you a minimum of 30 days' notice. And guys, this isn't a quiet little letter in the mail. It is read out loud in your town, glued to your house, slapped on the courthouse wall, and can even be blasted in the daily local newspaper. The state makes absolutely sure you can't say, "Oh, I didn't know."
If you ignore that massive public warning, the hammer drops hard. For crimes carrying 10 or more years, life, or death, the court can officially declare you a proclaimed offender. And right alongside that, under Section 85, they get the terrifying power to attach your property. Movables, immovables, the whole shebang. If the judge thinks you're going to sell off your assets and run, they can freeze everything at the exact same time they issue the proclamation. It completely paralyzes your finances to force you out of hiding.